says. Okay, for those of you in the courtroom, my hearing is technically on Zoom, so you'll be able to observe it on the big board, but I am about to start. It's 9 o'clock, so just everybody get ready. Thank you. Good morning, everyone. We seem to have been able to resolve our technical issues, and I do believe that this hearing is now being live streamed because it was set to be held by Zoom. Although I will note that my courtroom is open and there are people here also observing the proceedings, including, I want to let you know, we have two young people here who are watching and observing our court processes to either decide or cement whether and if they want to go to law school. So let's show them some fine lawyering and let's show them our most professional selves. Thank you all so much. In any event, before we get started, I do want to make sure, do we have a court reporter? Because I do not have a court reporter present, although I can probably manifest one if it's a last minute thing that needs to be accomplished. But my standing order does, or I think my notice of hearing says that if you need a court reporter, you have to get your own. Do we have one? Do we need one?
Judge John Merchant and Ashley Merchant on behalf of the plaintiff, we don't need it taken down, so we do not have a court reporter present today.
Okay, excellent. And is that good with the county as well?
Yes, it is fine with the county.
Excellent, just making sure. Okay, so we are here in the matter of the Merchant Law Firm versus Fulton County District Attorney's Office, case number 24CV001325. I'll note for the record that I am in the courtroom. This hearing is taking place by Zoom. And we'll go ahead. So I'm going to start by just telling you, I've reviewed the briefing. I've looked at the file. I'm going to give you just a brief background of what I think I understand about your case. And then because there is a motion to dismiss by the county, I think where I'm going to procedurally start is with the county arguing their motion to dismiss, because of course, if the motion to dismiss is due to be granted, then we don't need to get into the meat of the actual open records dispute that is at the heart of this matter. So what I think I understand about this case is that over the course of several months in 2023 into January of 2024, the Merchant Law Firm submitted a number of Open Records Act requests to the Open Records portal that is available on the Fulton County government website. Those responses, or excuse me, those requests were acknowledged in some form or another. Some it indicated no records, some it indicated there were records, but we're pulling them. Some, I think perhaps the Merchant Law Firm is unhappy with the nature of the responses. We'll get into that again if it's procedurally appropriate to do so in a moment. But the county, the Fulton County District Attorney's Office, who is the named defendant in this case, responded with a motion to dismiss, essentially arguing that the Fulton County District Attorney's Office is not an entity that is capable of being sued, and that if it is an entity that is capable of being sued under the Open Records Act, that the requests are moot because all of them were responded to, or including responses that say there are no such records, and that the District Attorney's Office acted in good faith in responding. I think that's where we are. And so I'm going to ask counsel for the Fulton County District Attorney's Office, which I believe is the County Attorney's Office, to go ahead and focus on that motion to dismiss. As I said, I don't want to talk about the substance necessarily unless and until we need to get there. So let's start with the motion to dismiss. Who will I be hearing from on behalf of the county?
Yes, my name is Sandy Monroe on behalf of the Fulton County District Attorney's Office.
Good morning, Ms. Monroe. Please go ahead.
Thank you so much for that brief introduction. And I'm just going to basically repeat most of those points to the court this morning. Defendant moves for dismissal for two reasons. The first being that as a matter of law, a district attorney's office is not an entity capable of being sued. This precedent is clearly established by the decision in Myers versus Clayton County District Attorney's Office. And according to Myers, and as highlighted in my supporting brief, the Georgia Court of Appeals held that neither the Georgia Code nor the Georgia Constitution establishes that the district attorney's office is a separate legal entity capable of suing or being sued. Now, this
Right, but isn't the Myers case though more focused on damages issues, or I think that was a 1983 case. I mean, you have to admit the Open Records Act is unique in the sense that it's not really, it's really focused on, or at least it tries to be limited to focus on the purpose for which it exists, which is to allow members of the public to obtain government records that ought to be public. And so I just wonder whether, although I agree with the general proposition that's stated in Myers and lots of other cases, that certain entities are not entities that are capable of being sued, and that probably the Fulton County District Attorney's Office is an entity like that. But for purposes of compelling an agency to obtain records, is there a difference here that matters under the Open Records Act?
I see here, I completely agree. I understand your point, Your Honor. The holding in Myers is a general principle, a principle that says that in every action, there must be a legal entity as to a real plaintiff and a real defendant. Let's not forget that the Georgia law recognizes only 3 categories of legal entities. Number 1, a natural person. Number 2, an artificial person, i.e. a corporation. And number 3, a quasi-artificial person. Now, the Fulton County District Attorney's Office is not a natural person, it's not a corporation, and is not a quasi-artificial person. Also, the District Attorney's Office does not fall under the definition of an agency as defined by the Open Records Act, which is adopted from the Open Meetings Act. My brief plainly explains that the plain inclusion of the word office is not within the definition of the word as the term agency as defined in the Open Records Act. My opponent would argue that the inclusion of the word office falls under the definition of agency, and that fails statutory and constitutional muster.
Well, but I mean, so my understanding is that the Open Records Act says that agency has the same meaning as the code section 5014.1, which is the open meeting section, right? And it defines agency as every state department, and it goes on. And then it says every county, municipal corporation, school district, or other subdivision of this state. And then it says every department, agency, board, bureau, office, commission, authority, or similar body of each such county, municipal corporation, or other political subdivision. And so I wonder if we're all not being too hyper specific on the word office. How is the Fulton County District Attorney's Office, agency, whatever we want to call it, right? The Fulton County District Attorney's Office, how is it not a department, agency, board, bureau, office, commission, authority, or similar body of Fulton County?
Because it's part of the judicial branch. As shown in the cases of Cogen, you have the district attorney's office, which is under the judicial branch and also under the judicial article of the Georgia Constitution. And because it is not applicable to a state constitutional officer, such as the district attorney, it's not applicable to its office. And that's where there lies a distinction.
Okay. So to put, I think one thing I'm struggling with though, Ms. Monroe, from your client's perspective is clearly Fulton County's district attorney is answering open records requests, whether they come from the merchant law firm or from anybody else who might want records, unless of course they're exempted in some manner by because they are work product or attorney client or prosecution investigatory, records, that sort of thing. And so my question, I've not known many government agencies that just give out things because they want to be kind rather than because they are legally obligated to. And so one question I have is, if the Fulton County District Attorney's Office is not governed by the Open Records Act, then why does the Fulton County District Attorney's Office have an open records agent, a records custodian, and a process and procedure in which it routinely engages to provide open records, to fulfill open records requests that are submitted to it?
Because it's part of their civic duty, a civic duty that is outlined in the Georgia Constitution. However, it doesn't subject them to suit. There is an immunity that also lies in this as well. You have here, the immunity is, excuse me, just give me a moment. The immunity lies in private suits. This argument that because the immunity, there's an immunity, I'm sorry, I'll start again. The Georgia Constitution unequivocally provides that the district attorney shall enjoy an immunity from private suits from actions arising from the performance of their duties.
Okay, so I forget, I apologize, Ms. Monroe, I have a lot of questions. So I apologize if I'm interrupting you, but how do you square that position, right, with Felker versus Lukemeyer and Chua versus Johnson? Both of those cases, one of them is from 2016. Both of those cases are open records disputes. Both of those cases, now granted, they were not against the office of the district attorney. They were against the named district attorney. But in neither of those cases did the Court of Appeals or the Supreme Court say, oh, but you can't sue the district attorney for these records. They were all concerned about the nature and extent to which those records constituted open records, the nature and extent to which they would be appropriate. And I'll note specifically in I think it's Chua, which is the more recent case, in discussing what was at issue in the case. I'm trying to find the exact quote because I have the footnote. It says, pursuant to this request, it's an open records request, the district attorney agreed to make the files available for personal inspection by Chua's attorney on July 24th, 2013. And then the Supreme Court, the Court of Appeals, dropped a footnote that said, COCGA 50-18-71A, quote, all public records shall be open for personal inspection and copying, except those which by order of a court of this state or by law are specifically exempted from disclosure. And so how do we square your position? Again, understanding that in those cases, the actual district attorney was named personally, but how do we square those cases with y'all's position that the only reason the DA provides those documents is because it's their civic duty, but that the DA's office is not subject to suit under the Open Records Act?
It's a great question, Your Honor. However, without the clear precedent of case law, and the application of how the Georgia Constitution and the Georgia Code is to be applied in a given open record setting, it's a difficult question to answer. But I can go by what's outlined in the Georgia Constitution and what their duties and what the district attorney's duties there lies, and that's what I go by. If there was an authority that would suggest otherwise, I would welcome to hear it, but I don't hear it, and nor has my opponent raised that. So it's a bit tricky as it pertains to open records, but what we can go by are the decisions that have been held by the court as it pertains to a district attorney's office. And this is those are the facts and circumstances present here.
Okay. And so not to skip around too much, but I think in response to I think that the reason there is in the record a motion to add a defendant in the form of Fulton County, the county of Fulton. And I'm assuming that's an effort to address this concern, right? That if the Fulton County District Attorney's Office is not the appropriate entity, then it must be Fulton County, which clearly would be subject to the Open Records Act. In fact, I think it's their portal that is being used to allow for input of requests and then to provide responses. But I also note that Fulton County objected to that. Is that something that you're handling, or am I now I'm pulling in one of your colleagues, or can you address that for me as well?
I can, Your Honor. So Fulton County cannot be added as a defendant for two reasons. The first reason is that the open records requests, which is the very underpinning civil suit of this action, were never made to the county. Okay, the county cannot be subject to a lawsuit that for violating an Open Records Act if there was no request made to the county. The Georgia Code is very clear in relevant parts. It states that the agencies shall produce for inspection all records responsive to a request. Here, there were several requests. However, not one of them, not one of the 13 were made to the county. They were made to the Fulton County District Attorney's Office. Secondly, the county should not be added as a defendant because the county is not the custodian of the Fulton County District Attorney's records. They have a designated custodian for those records, which is not a part of Fulton County. And to provide some context to the court, in 2016, the county created an open records portal designed to allow the public to request documents from the county and its departments as also to its respective custodians. Now, the open records portal is available to elected officials, and in this case, state constitutional officials like the district attorney. The district attorney's record custodian is completely separate and apart from the county. So the county would not have direct access to the district attorney's office records, again, because they're not the custodian. So to add them would be completely frivolous. And this is something that would completely be borne on the taxpayers of Fulton County, which is not what we want here.
Right. So one of the reasons that I was asking about Fulton County versus the Fulton County District Attorney's Office is I think what I'm struggling to understand is your position that the Open Records Act doesn't apply to the district attorney's office and its records in whatever way we constitute it? Or is your argument just that the wrong entity has been named? And if your argument is that the wrong entity has been named, then if it's not Fulton County, is it the district attorney?
So it is certainly, I'll start by saying that it's certainly not the Fulton County District Attorney's Office. And as far as suing District Attorney Bonnie Willis personally, don't believe that is something that can be done legally either. But what I've seen in my practice with open records is the suit against the district attorney in its official capacity. Now, whether or not that passes constitutional muster, that's something for the court to consider as well.
Okay. Okay. Thank you, Ms. Monroe. I apologize. With my questions, I've sort of jumped all over. I'm sure what you had was a beautifully outlined argument. So I apologize. If you'd like to take this opportunity to go back and make sure you've hit the points that you wanted to hit.
Sure. I think that's pretty much it. If the court has any further questions, I can address them, but that's pretty much it.
Okay. Thank you, Ms. Monroe. I think you have answered my question, so I appreciate that. So what I'm going to do now, because as I said, I want to focus on this issue of the motion to dismiss and the agency versus the Fulton County, et cetera. And so I'm going to go ahead and hear from the plaintiffs in response to that motion to dismiss.
Yes,
Mr. Merchant, please go ahead.
Yes, may it please the court, John Merchant, Ashley Merchant, on behalf of our firm, the plaintiff, the Merchant Law Firm. Your Honor, first of all, I want to welcome our young visitors, and I hope you enjoy today, learn a lot. And if anything I do or say causes you not to go to law school, then I apologize in advance. Ms. Merchant and I have been doing this for 20 years now, so we always welcome and are excited to see young people come into the profession in any shape or form, so welcome. I want to start, Your Honor, I think to give you some background about where this issue stands with our appellate courts. You may very well be aware that the Supreme Court of Georgia last month heard oral argument on this very issue. So I do want to caution the court, if I were in your shoes, I might not want to write an advisory opinion in advance of the Supreme Court's decision on this issue. Ms. Merchant has done the math and tells me there may well be a decision from the Supreme Court as early as
Are y'all referring to the Milleron versus Antonakakis case? Because y'all mentioned it in a footnote in some of the briefing, but nobody gave the case number or the case name. So I had to do a little bit of sleuthing and found it. But yes, I am aware that that case is out there and that the court was specifically interested in whether or not an employee working as a private contractor for their agency is governed by the Open Records Act. I understand the potential application that it might have in this case. So, but thank you for mentioning that.
Actually, Your Honor, it's a different one.
Okay. Okay.
Yeah. So the case that I'm referring to, and I've made opposing counsel aware of this as well. I'm sure she was aware of it anyway, but it's Gonzalez versus Miller. And that's in the Supreme Court. That's a case on interlocutory appeal.
Okay.
It was argued May 14th or so, I believe. The docket number is S24A0617. The oral arguments obviously are available online, and I've watched those, and I think they're informative for a couple of different reasons that you've already highlighted, Your Honor. The presiding justice Peterson equated what this suit is about under the Open Records Act when it involves a district attorney as sort of a mandamus-like case, where you're essentially asking the court to compel the production of documents.
Right, but there are some cases that say that if a statutory provision like the open records request provides a full and complete remedy, then there's no need to exercise mandamus.
That's exactly right, because it involves the court's equitable jurisdiction, which is unavailable if you have a legal remedy, which the statute provides. So we wouldn't even be able to file a mandamus against Ms. Willis personally to compel her compliance because we have a legal remedy. So that goes to the court's ultimate question, I think, is if it's not the DA individually, if it's not the district attorney's office and it's not Fulton County, what I've heard today suggested is that we would have to name Ms. Willis in her official capacity. Well, an official capacity claim really is nothing more than a claim against the entity. That's how the case law has interpreted the official capacity claim. So there's no difference, not procedurally or legally, whether we sue her in her official capacity or we sue the office. It's the same entity. So that's a distinction without meaning. So we've done the right thing. We've done what she's said we have to do. And I think Your Honor has appropriately distinguished Meyer, because that case, it really in passing in a paragraph at the end, sort of extrapolated the reasoning that had been applied to sheriff's offices and police departments to basically just say, well, we think it applies to district attorney's offices too. That's not true, Your Honor. And I think if you go back and you look at the oral arguments in the Supreme Court, presiding Justice Peterson pointed out that there's a difference between being included in the judicial branch, which I think everybody would concede the district attorney is included constitutionally in that branch. That's different than saying they have judicial power and therefore have immunity under that portion of the Constitution for compliance with the act. And I think if we look deeper, and I think the court, you have appropriately pointed out, we're dealing with a different monster here with the Open Records Act. It's a unique carve out. And yes, there have been exceptions under the Open Meetings Act related to applicability to the legislature. That has not been expressly said in case law with regard to district attorneys, and that's why it's in the Supreme Court now. That's why they're considering that. But Justice Peterson also appropriately pointed out in Article 6, Paragraph 8, Section 1D. He made a point of saying, and to perform such other duties as may be required to regulate the DA's office. That add-on language suggests, at least constitutionally, that even though the district attorney may be contained within the judicial branch in the Constitution, it contemplates that the district attorney would have additional duties with which to comply. And we'd argue, as Justice Peterson suggested, compliance with the Open Records Act is just one of those duties.
Right, which would be implied by the various and sundry exceptions that are carved out of the open records request, which would typically be records one would expect to find either having been created or maintained by a district attorney, like prosecution records.
Yes, Your Honor. In 1988, when they amended the statute, they did that in response to the court's ruling in Napper, which followed basically the federal rule with regard to open records on the issue of prosecution or pending litigation records. The very next session after Napper was decided, they specifically carved out an exception for pending prosecution records. And
So, well, forgive me for interrupting, Mr. Merchant, but I want to ask you the same question that I asked Ms. Monroe, because what I'm really struggling with here is the issue here that the DA's office, in whatever manifestation, whatever we call it, a sub of Fulton County, its own independent entity, Madam DA in her official capacity, it is the question. I mean, the question can't be whether they're governed by the Open Records Act. Doesn't it have to be who's the right person to sue for enforcement of the Open Records Act? Or are we really in a place where, despite cases going back to 1996 at least, where the Supreme Court is talking about enforcing the Open Records Act against a sitting district attorney, that you've just named the wrong party? And so let's figure out, because in civil cases procedurally, where there is a right that may be vindicated, oftentimes it's just a matter of determining who is the appropriate party, and let's get the appropriate parties before the court and move forward with the substance.
Yeah, and I think if frankly, I think we've appropriately named the office as the defendant, because that would be an official capacity claim against the DA herself. But
well, I mean, I don't want to be overly limited here, but I mean, I have said that I don't agree that Myers has applicability here in terms of the general proposition that such an entity has to exist in order to be sued. But let's not completely dismiss the county's point that the Fulton County District Attorney's Office is not a formal entity. It's not a municipal body. It's not an incorporated entity. It's just a name that we've given. I mean, if you were to sue a lot of the entities that are subject to the Open Records Act for some other violation, it would be, you'd be suing the sheriff or the DA or, the governor, right? I mean, that's how we do things in terms of suing for relief within the purview of those named elected officials.
Right, and we certainly can amend the complaint to add the district attorney individually and in her official capacity. If that solves the issue, then we're happy to do that. If this really is just a nomenclature issue and we just have the wrong party name, then we can save everybody a lot of time and just get to the heart of the matter and get the right people on the complaint. The thinking though was that an individual capacity claim would fail on its face because we didn't have any direct knowledge that Ms. Willis herself had responded to these requests, or that she had any input in responding to these requests. So we didn't have a factual basis to believe she somehow individually had participated. So that would limit us to the official capacity claim, which frankly, I thought we had done by naming the entity. I also do want to point the court to some statutes that I think shed light on whether the General Assembly believes that the district attorney's office is capable of being sued. It refers to the office in several different statutes. I'll just list them. I don't necessarily need to belabor the point by reading all of the statutes, but there are a number of statutes that the General Assembly has specifically referenced the office of the district attorney. It's 1585A. It's 1585G, 15184C, 15186.1, 1A, 151814.1, C3, 151814.1. All of those statutes, there's actually three others. 151828, 151828A, and then 151830A. All of those statutes, Your Honor, refer to the office of the district attorney, which I think highlights the point that, and again, it may be a distinction with meaning, it may not be, as to whether or not we sue her in her official capacity. But the General Assembly clearly makes reference to offices, as well as the district attorney as a constitutional officer in the judicial branch. I do want to highlight, though, and opposing counsel has referred to the three categories of entities that can be sued. And I don't want to harp on this if the court's already understanding the point. But the third says such quasi-artificial persons. And I think that's where opposing counsel stopped. But it says, as the law recognizes as being capable to sue. So that's what we have here. The law recognizes our ability to sue a quasi-artificial person. In other words, the office, not just by the plain language of agency, which includes the word office, as Your Honor has pointed out, but also in the case law that has been cited, it would classify into that third category. So I think, Your Honor, where we started, I think, and I don't want to get into the substance until Your Honor's made a ruling on the actual dispositive constitutional issue about whether we have the right person or not. They're operating with the idea that they are subject to the act, whether they're required to or not. They're in practice doing that. And Ms. Merchant and I, in another case, actually sent open records requests, the same one, to each of the district attorney's offices around the state, and not one of them said we're not subject to the act. And I think that is informative for a couple of reasons. One, I think that not only in practice do the district attorneys believe that they are subject to the Open Records Act, they are acting as if they are part of the act. And I think that's in accordance with what the General Assembly has established as the rule. After 1988, by creating the exception for pending prosecution, that was the General Assembly's notice of its intent to believe that the district attorney's office should be included as part of the Open Records Act. And to dovetail a little bit on whether or not they're part of the judicial branch or not, Rule 21 is the rule that provides for the production of court records. So if I wanted to get records from Your Honor's office, I wouldn't use the Open Records Act. I would use Rule 21, and there would be a procedure for that. Those are records that are within your custody and control. The records that we've sought here are not those type of records. They wouldn't.
Right. They're business operating type records. To the extent that I've looked at the substance of the request, I understand them to be focused on who works there, what are the programs that are in place, how are those programs funded, things like that. I understand.
Exactly, Your Honor. So those type of records could not in any sense be considered court records that would be subject to Rule 21. Those would the only way we can get those records, and frankly, they're public records for a very different reason, which is a lot of what we're asking for here, Your Honor, are records related to the use of public monies by the district attorney's office. The stuff that relates to media presence, that sort of stuff, time off requests, vacation types of things. Those are all things that if we don't have a mechanism through the Open Records Act to get that, there is no mechanism to get that. We have two ways. We either ask through the Open Records Act, or we ask through Rule 21. And if their position is, and I don't hear them saying that, but if their position is that they're just not subject to the act at all, then there's a whole panoply of records potentially related to public funds and expenditures that the public can never see. And I don't think that was what the General Assembly ever intended in creating the act and creating the exception for the pending prosecution. I did want to point out that Justice Pinson, it wasn't a long colloquy with counsel in the Gonzalez case, but the oral argument in that case, Pinson pointed out that official capacity claims are against the office, not the individual. He didn't say much and ask much in the oral arguments, but he did point that out. So, I do think that we've appropriately named the office, but if naming Ms. Willis in her official capacity solves the problem, then we can do that too.
Okay. Thank you, Mr. Merchant.
Yeah, if the court has any other questions, I'm happy to address them.
No, I think you've addressed my concerns. Ms. Monroe. It is your motion, and so I'm going to give you the last word. But I will ask that I'm not sure I've actually gotten an answer to my question. I think you've said that the reason that the district attorney's office is engaging in the process of and maintains a structure for requests is because it is the district attorney's civic duty to do so, which I don't want to assume, but I think implies that your position is that the DA's office is not legally obligated to provide or to comply with the Open Records Act. And so I do want to get a clear answer. Is the DA's position that it is not obligated, that it is not governed by the Open Records Act and therefore not required to comply? Or is it that the plaintiff has simply named the wrong entity? And part of the reason I'm trying to pin that down is, again, in a civil case, right, oftentimes if the substantive issue is appropriately before the court, then sometimes it's just a matter of let's make sure we've got the right parties here. This feels to me like we've named the wrong corporation and we need to get the right corporation named because it's a part of a corporate family, something like that. And so that's really what I'm trying to nail down. What is the DA's position?
The DA's position is that the wrong party has been named in this suit.
Okay.
Does the DA's office have a civic duty to make sure that there is public transparency as to how they are operating on behalf of its government, on behalf of its taxpayers? Absolutely. That is outlined without any question within the Georgia Constitution. Whether or not they are now subject to suit under the Open Records Act is what lies with the Georgia Supreme Court. And I am well aware of this case that is pending. It was cited in one of my footnotes to make the court aware. And I did view those oral arguments, and this is the issue. And so as far as liability, I think that is the bigger umbrella, which we will get to. However, we're just not quite there because, again, we have the wrong defendant.
Okay. Thank you, Ms. Monroe. Anything else you want to say in closing? Because, again, it's your motion, so you get the last word.
I just want to say that, from the onset of this case, we have tried to contact opposing counsel and trying to see if we can avoid litigating this matter. It was evident based on the case law, based on Georgia Constitution, based on statutes, Georgia code, that this was an improper suit brought against the district attorney's office. And they proceeded, which leads us to the next conclusion that this was merely to pursue the abuse of litigation, merely to pursue the harassment of the district attorney's office, and to further fish through business records that have already been provided. Now, I know the court doesn't want to get into the details or the merits of the open record request itself, but when we do get to that juncture, that would further reveal why we're actually here. If it was about open records, we would welcome that conversation, and we tried to welcome that conversation prior to even coming here, Your Honor. However, that was not something that we were able to do. So just some context for the court in making this decision today.
Understood, Ms. Monroe. Okay, so the main reason I was trying to sort of nail down that issue is I think that there is clearly an open question about the nature of the relief that the court might afford to the plaintiffs in this case, depending on the outcome of this larger issue in terms of the enforcement of the Open Records Act. But as an initial matter, to procedurally place this case appropriately, like I said, the plaintiff did try to amend the complaint to name a different party. I understand the Fulton County District Attorney's point that, the Fulton County writ large is not the custodian of the records that are sought by the plaintiffs in this case. But it does indicate that perhaps there might be a more appropriate agency, even if it's by addition rather than substitution. And so what I think I might do from a procedural perspective, I don't want to delay things unnecessarily, but I also don't want to get into the time and effort required to go through each of these requests and determine if they were responded to, if responsive documents exist, if they were perhaps documents that the DA's office would have been required to create. I mean, there are all sorts of substance that we'll have to get into if this is an appropriately postured suit that is capable of being urged against some entity that is the Fulton County District Attorney's Office in whatever way it's named. So here's what I'm going to do. I am going to invite the plaintiffs. I'm not going to deny or grant the motion to dismiss at this point. Because I think there is an open question as to whether the Fulton County District Attorney's Office is the entity that would be the representative of the office. But I also think that the plaintiff should have an opportunity, as they've attempted to do already, to move to add a party if they believe there's another party that might appropriately be named here to better posture the case between the real parties in interest, whichever appropriate legal entity that is, whether it's the district attorney in her official capacity, the district attorney in her personal capacity. But whatever it is that the plaintiffs decide, I'm going to give them an opportunity to do that. Giving them that opportunity will then give the county, the Fulton County District Attorney's Office, or whomever is named, the opportunity to move on that issue as well. And then it gives all of us the benefit of perhaps a ruling from the Supreme Court to answer some of the underlying substantive questions to determine if the right party is named. Do we then need to get into the granular? And so what I think I'm inclined to do is to grant 20 days from now for the plaintiffs to amend their complaint or move to add a party in whatever way they choose, to see if there is an entity or party that they might add that will be a more appropriate party procedurally. And then once they add that, I'm going to shorten it slightly to 20 days instead of the full 30 days for the county to file whatever motion to dismiss it chooses, whatever motion practice it might choose to file. And then obviously the plaintiffs would have an opportunity to respond to the motion to dismiss. And then perhaps at the 60 days from now, 70 days from now mark, we might be in a better position to know, to have some guidance from the Supreme Court on at least part of the issues here in terms of who is the appropriate party. Thoughts, concerns, questions about proceeding in that manner? Ms. Monroe?
That's perfectly fine with me, Your Honor.
Okay. Mr. Merchant?
We're in agreement, Your Honor. Thank you.
Okay. So we will enter an order that indicates that the plaintiff has 20 days from today, and I'm not looking at a calendar. I'm going to make it a weekday, so it'll be a specific date that it'll say you have until X date to file whatever additional motion to add party or motion to amend. It will be a specific date, roughly 20 days after that the county will have to file whatever motion it feels is appropriate. And then 20 days from there for the plaintiffs to file any response that they think is appropriate. Again, I understand I am shortening the time period that you would normally have. And if the parties can't comply with that and need specifically, you just need to reach out to my office and let me know, hey, can we have an extra couple of days? That's fine. We're happy to work with you. But we'll get that order on file today. And then what I will probably do just as a placeholder is go ahead and set another hearing date at some point roughly out from there. And then, of course, maybe we don't have to deal with any of this because the Supreme Court says one thing. And if we do have to deal with any of this, we'll deal with the procedure. And then if we get to that point, deal with the granular nature of the requests that have actually been posed. That's the plan. Is everybody good with that, Ms. Monroe? Mr. Merchant?
Yes, Your Honor.
Sorry, that is fine, Your Honor. Sorry.
Okay, excellent. Well, then we are adjourned. Thank you all for your time, and I will see you. I'll look for your briefing and see you in